Dumelang, sanbonane. How is everyone doing? How's everyone doing? I'm well, thanks. I'm well, guys. Just a bit struggling with flu. Otherwise, all is well, guys. All is well, guys. Before we go any further, guys, allow me to thank you, guys. Thank you very much, guys, for continuing to watch the channel, subscribing to the channel, and viewing the videos, guys. Thank you very much, guys. It is really and highly appreciated, guys. Guys, we're still dealing with the CCMA rules that were released in April this year. It's quite a thick document, guys. So we're still on part 5. Last week I did a video that dealt with part 5, but we couldn't do the whole of part 5 because part 5 is a bit thick. So we still continue with part 5 of the new rules of the CCMA, guys. Okay, let me not delay any further. Let me get to it, guys. We're going to be dealing with how to join or substitute parties to the proceedings. Proceedings is talking about the arbitration at the CCMA. Number 1, the commission or commissioner may at any stage prior to the conclusion of an arbitration or hearing make an order joining any number of persons as parties in the proceedings if the right of the referring party to relief depends on substantially the same question of law or fact, which if a dispute were to be referred separately against the person sought to be joined, it would arise in a separate claim, or B, the party to be joined has a substantial interest in the subject matter of the proceedings, or C, the party to be joined may be prejudicially affected by the outcome of the proceedings. Number 2, a commission or commissioner may make an order in terms of sub-rule 1, A, on own accord, B, on application by a party, or C, if a person entitled to join the proceedings applies at any time during the proceedings to intervene as a party. 3, an application in terms of this rule must be made in terms of Rule 31. Number 4, when making an order in terms of sub-rule 1, a commissioner may A, give appropriate directions as to the further procedure in the proceedings, and B, make an order, of course, in accordance with these rules. Number 5, if in any proceedings it becomes necessary to substitute a person for an existing party, any party to the proceedings may apply to the commission for an order substituting that party for an existing party, and the commissioner may make such order or give appropriate directions as to the further procedure in the proceedings. Number 6, an application to join any person as a party to proceedings or to be substituted for an existing party must be accompanied by copies of all documents previously delivered, including the referral form, unless the person concerned or that person's representative is already in possession of the documents. The application may be made at any stage prior to the conclusion of an arbitration hearing. Number 7, subject to any order made in terms of sub-rule 4 and 5, a joinder or substitution in terms of this rule does not affect any steps already taken in proceedings. Number 27, how to correct the citation of a party. If a party to any proceedings has been incorrectly or defectively cited, the commission or commissioner may, on its own accord, by consent of the parties or on application and on notice to the parties concerned, correct the error or defect. 28, when the commission may consolidate disputes. Number 1, the commission or commissioner may, of its own accord, by consent of the parties or on application and on notice to the parties concerned, consolidate more than one dispute so that the disputes may be dealt with in the same proceedings. Number 2, the commission or commissioner may order consolidation of separate disputes of right where A, the relief sought in each of the separate disputes to be consolidated depends on the determination of similar or substantially the same questions of law and fact. B, there will be no substantial prejudice on the party or parties sought to be joined through a consolidation order. C, the balance of convenience favor such consolidation, and D, the commission has jurisdiction Okay, just a minute, guys. Just a minute. Just a minute. Okay. All right. Okay, apologies for that, guys. Apologies for that. The balance of equivalence favors such consolidation. And D, the commission has jurisdiction in all disputes sought to be consolidated. Then go to 29. Disclosure of documents or material related to the dispute. Very key, guys. Number 1, at any time after the certificate of outcome is issued or the expire of the 30-day consolidation period, but not less than 14 days prior to the hearing, either party may, on application, request the other party to disclose any documents or material relevant to the dispute. 2, subject to Rule 31, subsection 5A and B, the party to whom the application is made must respond to the application within 5 days from the date on which the application was received. The party initiating the application may deliver a reply and written statement or affidavit within 3 days from the day on which any answer and written statement or affidavit was served on it. A commissioner, number 3, a commissioner may either before or during the proceedings at the commissioner's own accord or on application make an order as to the disclosure of relevant documents or material relevant to the dispute. Number 4, notwithstanding the above, the parties may agree on the disclosure of documents or materials relevant to the dispute. Number 5, this rule is to be distinguished from disclosure of information disputes in terms of Section 16 of the Act. Number 8, what happens if a party fails to attend arbitration proceedings before the commission? Interesting. Number 1, if a party to a dispute fails to attend or to be represented at any arbitration proceedings before the commission, and that party A was the referring party, the commissioner appointed to arbitrate must attempt to establish the reason for non-attendance. If there appears to be a good reason for their absence, the commissioner must direct that the matter be rescheduled for arbitration. Or B, if the absence is on the face of it willful or unexplained, or the commissioner does not accept the explanation, the commissioner may remove the matter from the roll. C, had not referred the matter to the commission, the commissioner may 1, continue with the proceedings in the absence of the party, or 2, adjourn the proceedings to a later date. 2, a commissioner must be satisfied that the party had been properly notified of the date, time, and venue of the proceedings before making any decision in terms of sub-rule 1. Okay, thank you very much, guys. That was part 5 of the new CCMA rules. In the next video, then we will deal with part 6. These rules are very important, guys. So when you know that you're confronted with any labor-related matter that you have to take to the CCMA, then you know which steps to follow, so you don't find yourself on the wrong side of the law, to ensure that you apply the correct rules. Thank you very much, guys. Please continue viewing the videos. Please share on the different platforms, be it Twitter, Facebook, whatever social media platform you're using. Please share the video. Please subscribe. Let's grow the channel. Asibonge, makhanye, lisedi.